The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your mostly bi-weekly podcast on the federal courts of appeal. I'm your host, John Ross, joined by Diana Simpson and Robert McNamara. If you're a 1L or 2L and you enjoyed this podcast, chances are you'll enjoy clerking at IJ this summer. Applications are open. We're also hiring a new attorney for our Minnesota office. To learn more about each of these opportunities, check out the links we've posted on our SoundCloud page. This week on the show, wasteful requirements for hair braiders, restrictions on free newspapers, and the ban on gun ownership for domestic violence misdemeanants. Diana, kick us off.
Yeah, so the first case we're going to cover today is an Institute for Justice case. This is something we litigated out in Missouri. And so the Eighth Circuit just issued this decision. And so there, Missouri has a 1,000-hour licensing requirement for people who want to become barbers and a 1,500-hour requirement for people who want to become hairdressers. And people who engage in the art of African hair braiding are required to obtain one of those licenses, even though those licenses have nothing to do with African hair braiding. And so what ended up coming out in discovery is that only about 10% of the required training for either barbering or licensing is even relevant to African-style hair braiding, and that the exams they offer for barbering and hairdressing don't even test the braiding. So what turns out is that these are just totally useless licensing requirements to have for a group of people who are trying to work for themselves and trying to provide a service that is very much wanted and taught and passed down from family to family. But the Eighth Circuit, in some crazy universe that we live, upheld this law and said that the state can exact a needless and wasteful requirement, and that's okay. And this is just outrageous, and that's the way that the world is sometimes, I guess, when it comes to occupational licensing.
I mean, I think the interesting thing about this opinion is it is very, very heavy on quotations of dicta from Supreme Court cases about how deferential they should be to the legislature, and very, very light on engagement with or even any reference to the record. I think it's kind of telling that the court hangs its hat on the idea that, well, 10% of the state has conceded that only 10% of its required hours are relevant to traditional African hair braiding, but the state doesn't need to regulate with mathematical exactitude, and 10% is maybe enough when there's no analysis of what that 10% is. The asserted justification for making hair braiders get a license is protecting the public health and safety from bad braiding and from scalp injuries and the like. And the court just breezes past the fact that when the state says that 10% of its hours are relevant to hair braiding, it's including hours in things like marketing and how to build your business, things that have nothing to do with the justification the court is accepting. And so the just complete disregard for whether the means the state is using have anything to do with the ends the state's lawyers are asserting that the state is pursuing is striking here. And particularly given the tenor of the oral argument in this case, which focused very much on the actual facts of the case and where the courts are supposed to draw the line. I think this opinion is surprising mostly in what it doesn't mention, much more so than in what it does.
And one of the reasons the Institute for Justice has been going after the rational basis test for so long is that it doesn't engage in facts, as Bob was just saying. And here, in one of the pages in the opinion, the court talks about what had happened at the district court, and same kind of problem. The state presented its evidence, the plaintiffs presented their evidence, and the district court then added two additional reasons the law might exist on behalf of the government. So essentially, plaintiffs are walking into a courtroom where two sides are advocating for the government, and the government wins.
What were the things that the court said were justifications for the law that the state didn't argue, but in fact the judge did?
The district court added two purposes: stimulating more education on African-style braiding and incentivizing braiders to offer more comprehensive hair care. So whether or not the braiders actually want to provide for more services, they might want to, or they should want to, and so the government could possibly encourage that by demanding they spend thousands and thousands of dollars on irrelevant education.
I particularly like the incentivizing education point, because that's the court playing off of, in discovery, we subpoenaed every single cosmetology school in the state, trying to figure out if anyone actually taught traditional African hair braiding as even an optional part of this curriculum. You have to take these 1,000 hours you have to spend in the school. And our argument to the court was, look, you have to go to the school. These schools don't even teach the thing our clients want to do. And the court's response was to say, well, maybe what the state is doing is forcing you to go to these schools in the hopes that the school will then spontaneously start teaching traditional African hair braiding, which strikes me as not a plausible description of what a legislator is actually doing in voting for a law, because it's something that you could apply to almost anything. Maybe to engage in traditional African hair braiding, you should have to spend 1,000 hours hanging out at a firehouse. Because if people have to spend that much time hanging out at the firehouse, maybe the firemen will be inspired to start instructing people in traditional African hair braiding too. If you just waste enough time, maybe eventually someone will come around. And I think that really goes to the heart of what we mean when we say a law has to be rational. It doesn't mean that in some abstract universe you can conceive of something good potentially maybe happening someday. I think what it has to actually mean, if we're going to be doing anything when we say a law has to be rational, it has to be rational in light of actual facts on the ground. So can you imagine a cosmetology school in Missouri teaching traditional African hair braiding? Yes, but I think what we actually have to care about is the real fact on the ground, which is that with this law in place, none of them do. And people are being forced to attend schools that do not teach what they want to do, then pass a test that does not test what they want to do, all in order to get the state's permission to do what they already know how to do and are in fact doing successfully.
And this isn't a minimal burden at all. I just want to highlight the fact that cosmetology school costs tens of thousands of dollars. And so this isn't like something you can go and get on a weekend and be done with it, like an easy certification, for instance. This is a really challenging and pretty large burden on folks who are just trying to earn an honest living.
And historically, those cosmetology schools are exactly the people who lobby in favor of restricting licensing laws like this, because cosmetology schools want more people to be forced to be their students, both so they can gather tuition dollars and, frankly, because cosmetology students are free labor for cosmetology schools. A lot of these hours you're required to spend in cosmetology schools are spent actually practicing on members of the public who pay not you, but pay the cosmetology school for your services. And so you do have this perverse feedback mechanism where people sometimes look at hair braiding regulation and they say, well, why do licensed cosmetologists care if someone engages in traditional African hair braiding? Because the cosmetologists don't do it. They're not really competing with the hair braiders. And really the underlying dynamic here really is schools. Cosmetology schools want as large a mandatory audience as possible. And so that's the lobbying force that is driving all of these increasingly restrictive cosmetology laws, both in terms of the total number of hours that are required, and as we see here, in terms of the overall reach of the cosmetology law itself, where it's stretching out to cover activities that aren't even taught by the schools themselves.
Okay, let's move on to the next case, which comes out of the Sixth Circuit. Bob?
The Sixth Circuit is facing an appeal of a preliminary injunction in a lawsuit against the Lexington-Fayette Urban County government. I always like the defendant names in these cases. And essentially, Lexington-Fayette has passed a law restricting your ability to leave unsolicited materials on private property, purportedly to protect the public aesthetic and to protect private property from being damaged and to reduce litter.
Yeah, cut down on litter.
And so the good people in Lexington-Fayette, through their elected representatives, have passed a law that's being challenged by a local newspaper that essentially produces weekly community news and distributes it. I think most of us get these on a regular basis. Some of us may read them, some of us do not, unlike this podcast, which you've all sought out voluntarily. And what the plaintiff argues is essentially this makes our business model impossible. What we do is we drive around town and we throw everything in people's driveways because that's the only way you can efficiently distribute a free newspaper. And under this law, the only way we can distribute unsolicited materials is by leaving it on the porch, putting it through a mail slot, or leaving it in between an outer or an inside door. It's kind of bespoke service of each individual newspaper. And that makes our business model impossible. And what the court has said is tough. The Sixth Circuit tells us that that is just too bad that this is a content-neutral law and that it survives intermediate scrutiny because the city is, in fact, advancing an aesthetic vision. And while you may not be able to do what you want to do, that is essentially just a difficulty for you and not a difficulty for the Constitution. And so the interesting thing here is that the law seems to be content neutral. It applies to material. It doesn't just apply to written material. For some reason, the district court found that it was content neutral but applied strict scrutiny anyway. And I've not had time to go and look at the district court opinion, but it seems like a strange situation where the parties are litigating with a district court opinion that they've both abandoned, which is always extra challenging as a litigant. And the thing that struck me, though, about the Sixth Circuit's actual intermediate scrutiny analysis here was how short shrift they gave to the actual burdens this is placing on the speaker. The Sixth Circuit kind of blithely says that maybe this is good for speech, that if you leave something on the porch or you put it through the mail slot, it's actually more likely that someone will see it and someone will be able to read it. And that just struck me as in bizarre tension with the party's actual argument, which is that in the face of this, they're literally going to stop distributing their newspaper. And if that's the case, it seems hard to imagine how more people are going to read a newspaper that is no longer being distributed.
Diana, would you read a newspaper that's no longer being distributed?
No, because I wouldn't know where to get it from. The interesting thing that really struck me about this opinion is how much strength the court saw in the evidence that the city had given. And so basically the city cites evidence that was produced in some other case out of the Western District of Kentucky. But that's okay. Cities can apparently rely on other data without worry. That's fine. But additionally, the city proffered this evidence that 2 members of the city council reported that they had observed unsolicited materials being washed into storm sewers, and one of the council members raised concerns that the impact on storm sewers may cause problems under a consent decree between the EPA and the city regarding, among other things, stormwater issues. That doesn't really seem to be data or evidence to me so much as anecdotal comments from city council members who may or may not be under oath or testifying or anything. They're just saying things that they've seen. Did they? I don't know.
They're kind of the sleeping giant in this case. It happens entirely in a footnote. It's important to remember this is just in the context of a preliminary injunction. The parties haven't conducted discovery, and the court just drops a footnote noting that the newspaper company actually contends that the whole purpose of this ordinance is specifically to ban their newspaper. And it's not developed by the panel opinion. Presumably it wasn't particularly developed by the parties because they don't have discovery yet. But it seems like that's really going to be the fight in the district court, because it's entirely possible that there's a city council hearing replete with statements about how the real evil facing this little community is this particular newspaper, and that this is a facially content-neutral law that is truly a nefarious attempt to ban a single newspaper. And so maybe in a podcast 18 months from now, we'll be talking about that opinion.
Well, so that's a good point. So if you were to ban this newspaper, or if you were to ban putting it on driveways, it's the same effect because the newspaper's going out of business, right?
Exactly. And so the thing they're going to have to kind of develop in the remaining proceedings in the district court is this just a genuinely neutral law that is about not dropping anything unsolicited in someone's driveway? Or is this actually a law that is passed for the purpose of reducing newspaper distribution? There's a footnote suggesting that that's what they contend, but the panel doesn't really grapple with it. I would assume there's just not much in front of the panel in terms of evidence of that proposition. But there's a big difference between passing a general law that makes a newspaper's business model more difficult and passing a law for the express purpose of shutting down a community vehicle of expression.
Diana, let's move to the last case, which also comes out of the Sixth Circuit.
So this case is about a federal law that eliminates the ability of domestic violence misdemeanants to obtain a gun, basically. And so the plaintiff in this case is a guy who 21 years ago pleaded no contest to engaging in domestic violence. He threw his wife against the wall, caused her some damage. He then spent a day in jail and got a $100 fine. He hasn't been convicted of another crime since then. So he's gone 21 years without any kind of problem. An important note is that the woman that he was married to in 1997, for whom he was convicted of assaulting, those two are now divorced. He hasn't committed a crime since then. In 2002, he went to buy a gun to defend his home and his family, and he failed the background check because of this conviction that he had. And so now he's challenging this law that prohibits him from getting a gun, saying that it unconstitutionally burdens his Second Amendment rights. And so the court looks at it, they look at the law, and they say, basically, no, it doesn't really cause a problem. There's no constitutional issue here because Congress has decided that domestic violence misdemeanants are violent people. Therefore, they cannot get a gun because we're preventing further crime and further violence. And then they cite a series of statistics and a series of studies suggesting that, or flat out saying that, violence is a problem, domestic violence is really commonplace, and that there is this continuing problem with recidivism for people in this area. And so they looked at a bunch of evidence, they cite a bunch of studies, and they say, okay, well, that's perfectly fine. This law does not violate the Second Amendment. And we're done here.
And there's a dissent which kind of eviscerates that, Bob.
Yeah, so Judge Boggs dissents, and Judge Boggs takes the position that those statistics don't account for the fact that there's been a 20-year gap here, that those are statistics about misdemeanants, which is a fun word to say, misdemeanants generally, and not about someone who has a 21-year conviction-free record, which is... It's a strongly put dissent, and I think the interesting thing here is just to watch the courts of appeals grapple with an area where there is so little law. There is basically one substantive pronouncement. I mean, really, there are two Supreme Court cases about Second Amendment rights in the modern era, and the second one doesn't break any new ground from the first one. So we're really just dealing with the DC v. Heller case, and that's all we have to go on, which leads people to just strange and difficult areas. I mean, I think Judge Boggs makes a very good point about the longevity and about the fact that time is a factor in deciding whether something is properly tailored. But at the same time, the Supreme Court in Heller did seem to say that you could permanently ban felons from possessing firearms. And if you can permanently ban felons from possessing firearms, why isn't time a similar factor in that? These are all things that get hashed out when you have a lot of case law about a particular right. And I think the Supreme Court's sort of staunch refusal to hear another gun rights case in the past decade is really leading to a lot of confusion in the lower courts. And you see that not just in debates like that between the majority and Judge Boggs here, but you see that just in courts struggling to figure out what the right's level of scrutiny is to apply to Second Amendment claims. The panel majority has an entire analysis trying to figure out whether strict scrutiny or intermediate scrutiny should apply here. And it tries to weigh factors like how much of a burden on the Second Amendment right this is, how close to the center of the Second Amendment right the asserted right is, and It just strikes me as a strange way to do the analysis because, at least in the First Amendment context, those are things that we do that go into our strict scrutiny analysis. We decide whether we're doing strict scrutiny or intermediate scrutiny, and then we look at things like how much of a burden on the right are you actually imposing? And so it seems like you're kind of doubling up the analysis here, but at the same time, I have sympathy for the panel because I don't know what level of scrutiny the Supreme Court has told us to apply to these rights, and there isn't a well-developed system to tell us what level of scrutiny. And so I think what we're seeing here is a lot of confusion kind of aided and abetted by the fact that we don't have Supreme Court guidance here.
And the majority alludes to that issue, too, because the majority cites the First Circuit, Fourth Circuit, Seventh Circuit, Ninth Circuit, and Tenth Circuit, each of which has now considered a post-Heller Second Amendment challenge to this subsection about misdemeanants. But each of them have upheld the statute, albeit under varying frameworks and rationales. There's really not many areas of the law in which you can have a challenge to a particular subsection of a statute and have different circuits applying different frameworks to figure out whether a law is constitutional or not. And that's just the world we're in now. I mean, there are certainly enough of these cases that the Supreme Court could take one if it wanted, but it sent a number of signals that it is not interested in one of those right now. Who knows? Perhaps this one might be it. Perhaps a future one might be it. But not at the moment.
Yeah, I mean, there have been a number of cert petitions on Second Amendment issues. They have been denied. And so really what we're seeing is a level of debate that you usually don't see in the federal courts of appeals, where people are disagreeing about fundamental questions like what level of scrutiny even applies, and where people are disagreeing about fundamental questions like what the unit of analysis even is. Is Judge Boggs right that in analyzing a law's fit, you have to look at the duration of the impediment the law is putting in place? That certainly seems logical. That is how we do it in the context of other rights. But there is, again, no Supreme Court authority you can point to either way. The Supreme Court has told us that a flat ban on firearms is unconstitutional. And in dicta in that same context, it has sort of listed a series of things that you obviously can do. And so everyone is stuck trying to reconcile those two poles. You obviously cannot, completely ban firearms for self-defense. And you obviously can ban firearm possession for felons. And how exactly you draw that Venn diagram, I think, remains an incredibly open question of federal law, and people keep bringing these challenges because, quite frankly, the Supreme Court has never said that these challenges are wrong.
Okay, that concludes the show. Thanks for listening, and be sure to tune in next time for more judicial engagement. This is John Ross from the Institute for Justice, invigorating you to get engaged.